This is a research case study presentation created and delivered by Zachary Edwards. There are two landmark cases that will be discussed through this presentation, with the first being New York versus Sullivan. The parties in this case involved New York Times Company, who was a defendant, and Sullivan, the plaintiff, who was one of three commissioners of Montgomery, Alabama. The facts in this case are that the New York Times Company printed a full-page ad entitled, "Heed Their Rising Voices." Some of the particulars within the ad were false, and no independent effort to check the accuracies of the information was ever completed. The defendant claimed it didn't have any reason to believe that its content was false. The plaintiff demanded that the defendant retract the advertisement, but since the defendant believed that their information was correct, they did not retract the ad. Sullivan felt that the publication implied that he was a co-creator of what was labeled an unprecedented wave of terror that had been directed against those who participated in the civil rights movement in the South. This is a statement that he felt hurt his reputation as a commissioner that had oversight over the police in Montgomery, Alabama. The element of defamation or libel in Alabama is that the publication is libelous per se if the words tend to injure a person in his reputation or bring him into public contempt. Sullivan, being a public official, he was required to prove that statements made were done so with malice. Initially, the decision was the jury awarded the plaintiff $500,000 in damages, and the Alabama Supreme Court affirmed. The defendant appealed that decision to the U.S. Supreme Court, and they felt that a defamation action, in this case, would severely cripple the safeguards of freedom of speech and expression that are guaranteed in the First Amendment of the Constitution and applicable to the states via the 14th Amendment of the Constitution. This conclusion was found because the plaintiff was unable to sufficiently prove the intent of malice. A case similar to this was Gertz versus Welch. Robert Welch Incorporated was a defendant and a publisher of American Opinion, that is described as a magazine that warns its readers of nationwide conspiracy to discredit local law enforcement. Elmer Gertz was a plaintiff and petitioner who was performing the profession of an attorney to a family whose youth member had been shot and killed by a Chicago policeman. Since the petitioner, Gertz, has not served on a city committee and has not appeared as an attorney at the coroner's inquest, he is not considered a public figure. The alleged defamation statements in the publication were that the petitioner had been an official of the Marxist League for Industrial Democracy, originally known as the Intercollegiate Socialist Society, which has advocated the violent seizure of our government, as well as labeling Gertz as a Leninist or a communist frontier. There were no actions by Robert Welch Incorporated to ensure that what they had reported was correct. The petitioner did not have a criminal record. He had been a member of the National Lawyers Guild some 15 years earlier, but there was no evidence that implicated they planned the 1968 demonstrations in Chicago. I believe the publication did have an effect on Gertz's reputation. These allegations potentially had a negative effect on his personal career and even possibly kept him from being employed by a client that heard of these allegations. To continue on that note, Gertz being an attorney, he has to sell himself to clients to earn a living, and if a potential client had heard of this publication and what was in it but did not know of the inaccurate statements, then there would be some type of income that Gertz might have missed out on due directly to this article. How Welch should have avoided a lawsuit. Simply put, his publication should have done investigative work to ensure that the information he was going to make public was 100% accurate. In Colorado, the defamation law states that 5 elements have to be met. Falsity, a defamatory statement must be false. Truth is an acceptable defense. Statement of fact, the statement must be false. Statement of fact relating to the plaintiff. Publication, the statement must be published or communicated to a third party. Fault in making the statement. At a minimum, for a statement to be defamatory, it must have been made with neglect or disregard. If the statement is about a public official, they must prove actual malice. Damages. Except in defamation per se situations, the plaintiff must show material harm in the form of economic loss, damages to reputation, or both. This information can be found on Kelly Warner's website that explains the Colorado defamation law and information. This is referenced on the final slide. Points of interest that I will be able to move forward with from these cases are that research and correct information are key. Not only that, but I would need to especially be certain that my information is 100% accurate if I am publishing something controversial that could potentially harm someone's image. And if I am 100% sure, then I would need to be prepared to share that evidence.